Good morning. The Subcommittee on New Offenses and Change Penalties will come to order. The clerk will call the roll.
Chair Louderback,
Here.
Vice Chair Moody, I'm sorry, Representative Moody, Representative Bowers, Representative Little, Representative Money.
Here.
Quorum is present. As a reminder, anyone present wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. Due to the number of witnesses who have registered and to accommodate all who wish to testify, there will be a time limit of 2 minutes per witness. During the public testimony period, please keep your remarks within that time frame. With that, we will begin. The chair lays out House Bill 2695 and recognizes Representative Manchia to explain the bill.
Thank you, Chairman Louderback, Speaker Moody, members of the committee. I wish I didn't have to be here today because this bill is born from tragedy. It stems from the devastating loss of life that we had in Carrollton, Texas, which I've represented now for 20 years, where fentanyl-laced pills were sold via social media and led to multiple juvenile overdoses and the deaths of 3 students. In late 2022 and early 2023, Carrollton Police, which you will hear from today, uncovered a fentanyl ring operating throughout the Carrollton Farmers Branch Independent School District. The ringleader used Instagram and other social media platforms to advertise and distribute counterfeit pills called M30. These pills were trafficked to teenagers attending R.L. Turner, DeWitt Perry Middle School, and Dan Long Middle School. And these pills were designed to look like prescription oxycodone, but were laced with lethal doses of fentanyl, up to 50 times stronger than heroin. 11 people were charged federally in connection to this case, and over the course of the investigation, officers made roughly 40 adult and juvenile arrests and seized more than 1.2 million fentanyl pills off the streets. It was a massive tragedy for the community. And at least 14 young people overdosed and 4 died. You're going to be hearing from some of the parents of those who passed away, including the mother of Jose Alberto Perez. Her name is Lilia Astudillo, and she has bravely shared her story in the hopes that no other parent has to feel the same grief that she has experienced. She got in a car at 3 a.m. this morning to be with us, and I'm grateful to the chairman for hearing this bill first. You'll also hear from Luis Gonzalez, who's also come down from Carrollton to testify, hoping that nobody else has to experience the insurmountable loss of losing a child. So the issue is that social media has become the new superhighway for drug trafficking. Using Instagram, Snapchat, TikTok, and X, drug traffickers now reach far more youth than before, and they reach them directly. Today, a 13-year-old in Texas can see an ad for pills laced with fentanyl and have them delivered to their door in a matter of hours. So what this bill does is it addresses this new tactic used by cartels and drug dealers and enhances penalties for use of digital tools that exploit and endanger Texas youth. Mr. Chairman, with that, I will turn it over to the people who have been closest to this work, and I humbly ask you and the committee members for the opportunity to close if you see fit.
Thank you. Members, any questions? If there are no further questions. Money.
What is the hole in the existing law? Because you said that the people that were involved in that horrible tragedy were arrested. It sounds like things are moving in the criminal justice system. So what is the exact problem that this bill is trying to address?
It gets at advertising drugs over social media, which is not illegal.
Okay.
Right. We want that if you use this new superhighway to do your drug dealing, to do your cartel activity, we want it to represent a penalty enhancement just because of the sheer scale and reach and targeting of youth that this represents.
Okay. Thank you.
Thank you, Representative.
Thank you.
Thank you, Mr. Chairman.
Let the record reflect that Representative Little is here with us. If there are no further questions, the chair will call the first witness. The chair calls Lilia Astudillo.
Mr. Chairman, with your indulgence, I've signed the forms to be able to translate for Mrs. Lee.
Okay.
Hola, mi nombre es Lilia Astudillo.
Excuse me just a minute. Thank you for being here. We show you registered as Luisa Ansadilla, and you represent herself. Okay, and you are testifying on for or against House Bill 2695, is that correct?
Yes.
Yes,
Sí. Sí.
yes.
For.
Está preguntando si está a favor.
Let me re-clarify again. You're for the bill?
Si está a favor de la propuesta.
Sí.
Okay, thank you.
Yes.
Okay, go ahead.
Mi nombre es Lilia Astudillo. Soy la mamá de José Alberto Pérez.
My name is Lilia Astudillo. I'm the mother of José Alberto Pérez.
Yo he luchado contra esta pastilla mortal fentanilo.
I've been fighting against this deadly pill, fentanyl.
Una sola pastilla mató a mi hijo.
A single pill killed my son.
No debemos permitir que sigan muriendo nuestros hijos.
We must not allow our children to continue dying.
Ellos son unos niños, son el futuro del mundo
Our children, they're the future of the world.
y se debe castigar a los responsables
And those responsible must be punished
como asesinato.
for murder.
Debe ser más fuerte la ley contra las personas
The law against people who sell these drugs must be stronger.
que venden esta pastilla por Instagram, TikTok,
For the people who sell these drugs via Instagram or TikTok,
Snapchat,
Snapchat,
que son por donde nuestros hijos las agarran.
which is where our children are acquiring them.
Llevo más de 2 años luchando por esto
I've been fighting for this for more than 2 years
porque ninguna madre debe sentir este dolor
because no mother should feel this pain
de perder su hijo por esta droga mortal.
of losing their child to this horrible drug.
Una sola pastilla cambió la vida
A single pill changed my life.
de mis hijos, que son 5 hermanos,
My children are 5 other siblings,
y una madre que lo amaba y hoy llora su ausencia.
and a mother who loved him, and to this day I mourn his absence.
Lucharé en su memoria
I will continue to fight in his memory.
y porque ni un niño más debe morir por esto.
And no more children should die as a result of this.
Gracias.
Thank you.
Thank you. Members, are there any questions for this witness? Representative Moody.
I don't have a question, but I just wanted to thank you for being here. And I know it's incredibly difficult to tell your story, but it's important for people to hear it so that this doesn't happen to anybody else. So thank you for being here.
No tiene una pregunta, sino le quiere decir que le agradece su participación en el proceso porque ningún padre de familia debe vivir esta tragedia.
Solamente quiero decirles que nos ayuden
I only want to say, please help us,
a que no siga pasando esto,
let this not continue.
Thank you.
porque no discrimina a nadie, puede ser cualquier persona mañana.
This drug doesn't discriminate, could be anybody tomorrow.
Es todo.
That's it. Thank you.
Thank you very much. The chair calls Luis Gonzalez. Good morning. Thank you for being here today. We show you registered as Luis Gonzalez,
Yes, sir.
and you're on for or against House Bill 2695.
Yes, sir.
Is that
Yes, sir.
state your position?
I'm sorry.
On, for, or against?
I'm a favor of the bill. I'm in
Okay.
favor of the bill.
You're for the bill?
Yes.
Okay, thank you. Go ahead.
Okay. The only thing I have to tell you guys is 16 years ago, my daughter came to our lives. That was beautiful. She brings happiness. She brings music. She brings everything to our lives. Thanks to this drug, everything changed. The music, the laugh, everything stopped in my house. My wife lost her daughter, her friend. I lost my everything. When she left, part of me left with her. My son lost his top supporter. The only thing I ask you guys is please help us. I hope nobody else, no other family has to go the same thing we're going through. It's really hard for me, like, I got a lot of things to say and try to tell you how I feel. But there's no words to describe what this is doing to families. And I just like, I'm sorry. Thank you.
Okay. Members, are there any questions for this witness?
Yeah, I'm sorry.
Thank you, sir.
Okay.
The chair calls Joanne Guillen. Thank you for being here today. We show you registered as Joanne Guillen, and
Gillen,
you're and for or against the bill?
4.
For the bill, thank you. Go ahead.
Yes. I represent Carrollton Farmers Branch Independent School District, and I was directly involved in the chaos that occurred last year. When we interviewed students and asked them how they were getting their drugs, it was predominantly through social media, and it could be delivered directly to their front door or their bedroom window. It was very difficult for us to provide the education that we needed for our students because the addiction is so profound. But what we did to get a grasp on this is we worked with our parents because we wanted our parents to know that their cell phones, that was the avenue for students to buy these drugs. And the drugs were not expensive. This was happening to our 6th, 7th, 8th, 9th, on up grade students, as young as 6th grade. So what we did is we provided parent education so that parents would become the CEO of their family. Take it back. Take back the control over the phones and the students' usage of social media. But this is absolutely how it occurred, was through social media, the purchase. Thank you.
Members, any questions for this witness? Thank you. The chair calls Robert Arredondo. We've got you listed as Roberto Arredondo. Thank you for being here today. You are testifying on, for, against 2695?
4.
Thank you. Go ahead.
Good morning, Mr. Chairman, members of the committee. Thank you for the opportunity to speak before you today on a matter of urgent concern. My name is Roberto Arredondo, and I serve as Chief of Police in Carrollton. I am for House Bill 2695. I appear before you not only as a law enforcement leader, but as someone who has witnessed firsthand the devastating impact that the trafficking of fentanyl and other dangerous drugs has had on our communities. Let me be candid. Since 2023, our street crimes unit has initiated 108 fentanyl-related investigations. Alarmingly, approximately 55% of those cases involved offenders using social media platforms as their primary tool for trafficking and distribution. These are not fringe platforms. They include widely used apps like Instagram, Telegram, Facebook Messenger, Snapchat, and even Leafed Out. In short, traffickers have traded street corners for smartphones. And they are reaching deeper into our communities than ever before. The numbers we are seeing are staggering. Since 2023, our department has seized over 5,200 grams of fentanyl citywide, 4,700 grams of that through our street crimes unit alone. To put into perspective, as little as 2 milligrams of fentanyl can be lethal. We have confiscated enough to kill millions. But fentanyl is only part of the picture. Since 2023, our dedicated street crimes investigators alone have seized over 56,000 grams of methamphetamine, 1,300 grams of cocaine, 55,000 grams of marijuana, 31,000 grams of THC, and nearly 20,000 grams of other narcotics, including heroin, LSD, MDMA, psilocybin, and illicit pharmaceuticals. In total, the estimated street value of these seizures exceeds $4.5 million. And alongside these drugs, we have confiscated 107 firearms, highlighting the undeniable link between narcotics trafficking and violent crime. The human toll is even more sobering. Since 2023, we have arrested 385 adults and 26 juveniles for fentanyl-related offenses. We have responded to 72 overdose incidents, of which 12 were fatal, including the tragic deaths of 2 juveniles. These are not just numbers to us. These are lives lost, families devastated, futures erased. Law enforcement needs every available tool to combat these evolving threats. Without stronger penalties, we are outpaced by traffickers who adapt their methods with alarming speed. This bill will help us hold them accountable and deter others from exploiting these platforms. Thank you for your attention. I'm open for any questions you may have.
Chief, let me clarify, you're representing
The Carrollton Police Department
Carrollton
and
Police
myself.
Department and yourself.
Yes, sir.
Thank you. Are any members, do we have any questions? Representative Little?
Chief, thank you for being here. I know it's a sacrifice of your time to testify on this important bill. This is very important to our community, and I look forward to voting it out. Thank you for all that you do in keeping my community safe.
Yes, sir. Thank you for your support.
Yes, sir.
Representative Money?
Yes. Thank you. I just have a technical question. I think this is obviously a huge problem. Most people are communicating through social media these days. I know I have kids, 21 down, and a lot of their friends don't even have a phone number. They just communicate through Snapchat or DMs through social media platforms. So my question is, just as a law enforcement officer, how is this going to be a part of your process? If you find someone who has a controlled substance, you're asking them, where did you acquire this, whatever, and if they say, I got it through a Facebook DM or through Snapchat or whatever, all of a sudden that becomes an enhanced crime? Is that the way that that's going to work?
Yes, sir. But I want you to understand that these are sometimes complex and long-term investigations, and we follow it wherever it goes. Not all of these numbers are just Carrollton. In Carrollton, we're taking the load for the entire state if we have to. We are following it wherever it goes. We're working with our federal partners to ensure if it's anything that's on the national level, we follow it there as well through our federal partners. What we're seeing through these long-term investigations is in our communication with our users, victims, they're explaining to us how they get it, how they were approached. And so we're looking at that as a part of our regular investigations as we move forward, and we have been for some time now. What we're seeing is the juveniles are being approached with coded emojis, different types of fancy advertisings to attract kids. You're looking at fentanyl pills that look like Skittles. They're working diligently to attract our youth. They are killing our youth. And what what happens on top of that is our officers, and we're talking about officers' well-being nowadays, their mental health, are having to go to these scenes and see these kids and these families. And you saw the hurt today. And this is why we're so passionate. And this is why we put all hands on deck in Carrollton to ensure that we save our children. There's nothing more precious than our children. So we're doing whatever we can to do that. And we thank the representative and the chair today for this opportunity, because it is too important not to do this.
Thank you. What percentage of basically drug delivery or trafficking to these days that you see involves some sort of social media?
In the numbers I gave
communication?
you, over half,
Okay.
55% in my department, and that's quite a bit. I use a lot of resources in a department that's very thin, and you know how difficult it is today to hire police officers, retain police officers.
Right.
I have taken the resources necessary to do those things so that we can follow those long-term investigations.
And I mean, the effect or impact of this legislation, were it to pass, would be an enhancement on 55% of your drug cases,
Yes.
basically.
Yes.
Okay. Thank you very much.
Yes.
Chief, can you clarify for us a brief description of a transaction that would take place where the exchange took place?
Sure. What we saw in our school district were a drug house, a drug dealer would recruit students to sell. They had the Snapchat or Instagram of other students. They started advertising that drug sale, and the kids were buying it. And we were seeing numerous ODs of kids and adults, young adults as well. But basically, it's like anything you're selling on Facebook Market or Instagram or whatever it is. It's just an advertisement. They're running a business, except this business will kill you.
And Chief, did you find out who was behind this?
We did. We found for that sale, we arrested, we actually had the house demolished. They're out of business. They're in federal prison. However, it's everywhere. I mean, it is everywhere. And what we're all learning, what we have seen in our social media searches, is that they're saying, I'll meet you anywhere but Carrollton. And they're everywhere. And that's because we've taken such a hard stance on drug trafficking in our city.
Thank you, Chief, for being so diligent on this, and a very real problem that we have here in our state. Thank you. Members, any other questions? Thank you, sir.
Thank you all very much.
Is there anyone else who wishes to testify on, for, or against House Bill 2695? If not, the chair recognizes the representative Anchia to close on the bill.
Thank you, Mr. Chairman, Speaker Moody, and members. If there are no further questions, I close.
Mr. Chairman. Sorry, not a question. I was going through the different code provisions that it captures, right? So we're focusing on fentanyl here, which sits in a certain penalty group. You got multiple penalty groups that are touched by this enhancement. Just my 2 cents. You included here is delivery of marijuana at misdemeanor levels that bumps everything up. And I don't know if that's.
We want to be flexible to capture the fact pattern at hand. Yeah, I did see that. We will be having a committee substitute before you.
So even within the marijuana delivery, right? So state jail, I mean, when you get to state jail level marijuana delivery, you are talking about a lot of drugs.
Yeah,
So
yes.
I would say absolutely you want to keep it in those categories. I think on the misdemeanor levels, you're taking things that most departments are treating as pushing down the grade of penalty, and this would automatically enhance. And this is the way that everybody communicates now, so you're going to bump up a lot of low-level offenses. That's the only concern I would have. Everything else makes sense to me.
So you're right. It's a good catch. We had caught it as well. We'll make sure we have a committee substitute that calibrates the penalty to the crime.
You don't have to change it from. You do not have to change it on my behalf.
No,
I'm just noting it.
No, it's good. It's a good catch.
Yeah.
Seeing none. Thank you, Representative Anchia.
Thank you, Mr. Chairman.
If there is no objection, the bill will be left pending. If there is objection, the chair hears none. House Bill 2695 is left pending. 1795, let's see here. The chair lays out House Bill 1795 and recognizes Representative Anchia to explain the bill.
Good afternoon. I want to make sure I have we're talking about cockfighting. Yes. Thank you. State of Texas is currently facing a challenge with cock and dog fighting. And for those unfamiliar, these are blood sports that weaponize innocent roosters and dogs in fights to the death for the mere purpose of gambling and entertainment. Regularly, we see these as magnets for other illegal activities, including drug proliferation, theft, human trafficking, illegal possession of firearms, essentially under an umbrella of either organized crime, cartel crime, or gang violence. By increasing penalties for dog and cockfighting from a misdemeanor to a felony offense, the experts with which we have discussed this, they believe that it will deter crime and reduce recidivism rates across the state. Our localities in Dallas, who spend a lot of resources, a lot of staff power trying to deal with these high-risk sting operations, turn around and just see the criminals receive just a little more than a slap on a wrist, just a misdemeanor, and they're back out on the streets doing it again and again and again. And it's very lucrative. And the smaller fines in Stinson County Jail become worth any risk when it comes to organized crimes putting together these fights. Over 40 states like Louisiana and New Mexico are already classified cockfighting and dogfighting as felonies, and Texas should do the same. Mr. Chairman, we have a number of witnesses here who are experts on the matter. I ask, to the extent you have questions about dog or cockfighting, you please ask them extensive questions. And with that, Mr. Chairman, I humbly ask for the opportunity to close.
The chair offers a committee substitute.
Yes.
Thank you. Members, are there any questions for Representative Anchia? Thank you, sir.
Thank you, Mr. Chairman.
The chair will call the first witness, Jessica Treviso. Thank you for being here. We show you registered as Jessica Treviso,
Yes, sir. Yes, sir.
and you represent
The State of Texas Dallas District Attorney's Office. And-
Dallas County
Yes, sir. And for the bill.
for the bill?
Yes.
Thank you. Go ahead.
Thank you, Your Honor. Good morning, Chairman and Committee. My name is Jessica Treviso, and I'm here representing the Dallas County Criminal District Attorney, John Crusoe, in support of HB 1795. I am the Division Chief of the Animal Cruelty Division and Community Prosecution Unit and have been a prosecutor for over 13 years. HB 1795 aims to increase the penalty range on anyone who owns or trains a cock with the intent that the cock be used in an exhibition of cockfighting, and anyone who uses or permits another to use any real estate, building, room, tent, arena, or property for cockfighting from a misdemeanor A to a state jail felony. So right now it's a Class A misdemeanor, and it would be bumped up to a state jail felony. Cockfighting is a blood sport that breeds violence. It breeds drug trafficking. It also costs taxpayers millions of dollars for cases that are currently mainly filed as misdemeanors, because rarely do we ever catch them in the actual act of cockfighting, which is a felony. The majority of our cases originate through surveillance operations, executing search warrants, and finding perpetrators in the possession of cocks with evidence that they are being used and bred and trained for cockfighting. The evidence we find are dubbed cocks. Roosters are dubbed, meaning their combs, wattles, and earlobes are removed before cockfighting to minimize the risk of bleeding during the fight. They dub the cocks in order to win fights, not for veterinary practice or health reasons or safety reasons, but for a blood sport. If someone is in possession of a dubbed bird, there's only one reason: cockfighting. These birds have a street value ranging from $500 to $2,500 per cock, plus winnings from the fights, plus earnings from leasing the land, pens to house, anything from $50 a day to $100 a day just to lease out a pen to house this cock that is going to be used for cockfighting. This is a lucrative business for landowners and cock owners at the expense of the taxpayer. And if they are leasing the land or leasing a pen, it's only a misdemeanor. So they essentially earn in one day what they can pay their fine and get out of jail on a Class A misdemeanor. In the case I worked alongside of the Dallas Police Department and Dallas Animal Services in March, April 2023, DPD was called out for an aggravated assault, a shooting case. It started out when narco cartels from the Michoacan cartel got in a shootout because someone lost a cockfight. DPD responded, and they ended up getting search warrants that turned up to almost 3,000 birds dubbed and trained for cockfighting. But we also found firearms that were linked to other offenses and evidence of narco activity like the Santa Muerte shrines. DPD had to sort out not only the firearms and their connection to illegal cartel activity, but also what to do with 2,731 legally seized birds. The Dallas Police Department was incredible, and Chief Igo, who was over that unit at the time, was instrumental in making that operation work. However, at the end of the day, it ended up costing taxpayers 2,731 birds were seized, and we seized them for about 10 days, which is what the statute requires. It cost us $1,744 for a misdemeanor offense. In 2023, our unit worked tirelessly with the Dallas Police Department to seize over 3,400 animals. In 2024, we seized over 1,200 hens and roosters. Currently, there is little deterrence for offenders who are arrested for possessing or training cocks that have evidence they will be used in cockfights, or for those landowners who lease pens to keep the cocks or land to hold the fights. They get charged with a Class A misdemeanor, take probation time, time served, and they have little to lose and everything to gain. You may think that seizing birds used in cockfighting rings is not as important as taking down a drug house, although that is very important, but cockfighting rings also inflict serious bodily injury on the animals, but they also breed criminal episodes of drug sales, trafficking, money laundering, cartel infiltration, and violence at all expenses to the taxpayers. I ask for your favorable consideration of HB 1795. Thank you, and I'm open to any questions you may have.
Thank you. Members, any questions for this witness? Thank you.
Thank you for your time.
The chair calls Katie Turner. Chair calls Katie Turner. The chair calls Sheriff Brian Hawthorne. Thank you for being here today, Sheriff. We show you registered as Brian Hawthorne, and you represent?
I represent the Sheriff's Association of Texas and myself.
And yourself. Thank you.
And
you're testifying on for or against?
testing for the bill, testifying for the bill.
Thank you.
The Dallas County ADA summed up. There's not much I can add to that. What I will tell you is that the majority of these cockfighting and dogfighting rings are usually in rural Texas, so they very quite often fall in the hands of the sheriff to try to sort it out, and they happen from North Texas to South Texas, and cockfighting in particular is getting more prolific, and we're seeing it more and more across the state. It is truly a blood sport, just as she said, and just as Representative Anchia said. I think this is interesting on the week of what we call Animal Services Week. This is all about sheriff's offices and cities that have animal control programs. This is the week honoring them, and I think it would be great for you all to pass out a bill protecting all animals, whether it's a rooster or a dog. This is a good bill, and the Sheriff's Association thanks you, Chairman, for having a hearing on it, and we appreciate Representative Anchina for trying to protect animals.
Thank you, sir. Questions for this witness? Sheriff, I have one. If you'll give me some idea on some infrastructure behind this, on who's behind a lot of these situations.
Well, primarily they're gambling operations. It's all about the winners and the losers. It's a very, very bloody. It's usually done inside a barn. Normally how they're discovered is because another crime takes place. With social media and other ways of communicating, they'll create an atmosphere and bring everybody in, usually to a barn. Many times we discover a barn that may have 50 cars at it. You know there's something going on when it's 10 o'clock at night on a Saturday night. But there's a ring, and it's full of people, and it's a cash operation. She's exactly right. There's lots of guns, lots of drugs, lots of alcohol. It's just a bad mix. And and it's all about the gambling. We don't allow casino gambling in this state, so I don't know why we would allow cockfighting gambling and not make it a felony. And that's truly what this is about, because the ADA summed it up. At this point, it's not a penalty enough to deter. And honestly, it's a very hard one to prosecute, trying to identify exactly who the players are in a mix of 150 men and women that are all scrambling in all directions as the sheriff's office or the police department walk in to break up the cockfighting operation.
Sheriff, are you seeing any organized crime?
It is clearly organized crime.
Are you seeing any cartel activity?
Well, in my world, we have not seen cartel activity, but I know that in South Texas, they've seen a lot of cartel activity, and then up in North Texas, kind of up around the Tyler, Longview area where they're starting, it's growing. It's very cartel related.
Thank you. Members, any questions? Thank you, sir.
No, thank you, Chairman.
Chair calls Courtney Burns.
Thank
Thank you for being here today.
Thank
We
you.
show you registered as Courtney Burns,
Yes.
and you represent?
The SPCA of Texas and myself.
State that again, please.
The SPCA of Texas and myself.
And you're testifying on for or against House Bill 1795?
4.
Thank you. Go ahead.
Thank you. Mr. Chair, members of the committee, my name is Courtney Burns, and I serve as the Chief Investigator of the SPCA of Texas's Animal Cruelty Investigations Unit. Thank you for the opportunity to speak in support of House Bill 1795. We stand with the Dallas County District Attorney's Office, the Sheriff's Association, and law enforcement agencies across Texas on this important issue. House Bill 1795 targets animal fighting operations, violent, deeply entrenched criminal enterprises that bring widespread suffering to animals and endanger entire communities. Animal fighting is linked to other serious crimes. It's connected to dangerous organized criminal networks, illegal drug and weapons trafficking, theft, and other crimes hiding in plain sight across our state. These operations are a menace to the communities where they operate. Texas is only one of 2 states, New York being the other, where breeding, training, and selling dogs for fighting is only a misdemeanor. House Bill 1795 would change that. Under current law, those who cause animals to fight face a state jail felony, but others who train and sell animals to fight face only a Class A misdemeanor, a slap on the wrist. The people who traffic animals for fighting profit tens of thousands of dollars and fuel the international animal fighting industry. A misdemeanor penalty is not an effective deterrent. Over the past decade, the SPCA of Texas has partnered with law enforcement on dozens of animal fighting busts across North Texas. These investigations have uncovered hundreds of suffering animals and led to numerous arrests. Just 16 days ago, in Hunt County, we seized 65 live and 10 dead roosters from an active cockfight. We also found syringes, narcotics, and evidence of illegal gambling. Sadly, this is not the exception, it's the rule. A 2024 poll shows that 74% of Texans, including 82% of Republicans and 70% of Democrats, support stronger laws against animal fighting. As a national leader in criminal justice and safety, it's time for Texas to send a clear message that animal fighting and the crimes that come with it have no place here. I respectfully urge you to support this legislation. It will protect animals and people and make our neighborhoods safe.
Thank you.
Thank you.
Members, any questions? Thank you.
Thank you.
Chair calls Amber Green. Thank you for being here today. We show you registered as Amber Green,
Yes, sir.
and you represent who?
Myself and Smith County Animal Control.
Smith County Animal Control. And you're testifying on for or against
4.
for the bill. Thank you.
Yes, sir. Thank you, Chairman. Thank you, Chairman, and members of the committee for the opportunity to testify in support of House Bill 1795. My name is Amber Green, and I serve as the Director for Smith County Animal Control Department, specializing in the investigation and enforcement of animal cruelty and fighting crimes here in Texas. I've worked on numerous cases involving dog fighting and cockfighting and other serious forms of animal cruelty. In one of the cases I've investigated, we seized 60 fighting dogs. We recovered cash, illegal narcotics, and firearms. Children did indeed reside at the residence. The brutality of what those dogs endured is something I will never forget. House Bill 1795 provides much-needed tools to ensure law enforcement can hold offenders accountable. Specifically, it makes almost all offenses associated with animal fighting a felony. This is important because every act and every participant, from the dogfighters, breeders, and trainers, to the event organizers and spectators that fuel this violent industry. It sends a message that Texas takes these crimes seriously and that our state will not tolerate cruelty, violence, and organized crime hiding behind the cover of animal ownership. This bill also aligns Texas with the National Sheriff's Association and the administration's stance on animal fighting. After the recent conviction of Oklahoma dogfighter, FBI Director Kash Patel said, "The FBI will not tolerate criminals that harm innocent animals for their twisted form of entertainment." The FBI views animal cruelty investigations as a precursor to larger organized crime efforts similar to trafficking and homicides. Again, I urge you to support House Bill 1795. Thank you for your time and your commitment to public safety.
Thank you. Members, questions? You represent Smith County Animal Control and yourself?
Yes, sir.
Okay, thank you.
Yes, sir.
We need permission. Evidently, you registered as different. Do we have your permission to change this?
Yes, sir. I apologize.
Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 1795? If not, the Chair recognizes Representative Anchia to close on the bill.
Thank you for the opportunity, Mr. Chairman, members of the committee, for the early hour and the audience during this early hour. I'm happy to answer any other questions, and if there are none, I close. Yeah.
I have a quick question, and I should have probably asked the Assistant DA that was here from Dallas, but what are some other state jail felonies that this would be in line with? I'm not a criminal lawyer, so.
Neither am I.
Yeah.
I have to confess, I am a corporate finance lawyer representing banks and non-bank financial institutions.
Yeah.
So I is beyond my scope.
Yeah, and Mr. Moody just left. He probably would be able to answer that.
Give me your question. We'll research this and get it to the committee.
I'm trying to just make sure that this would be a crime that's in line with other crimes in that same category. What other state jail felonies are there to ensure that we have parity and that it makes sense in the law? But thank you for bringing this to our attention. That Hunt County cockfight that the SPCA lady was talking about is about 10 minutes from where I grew up and where my parents still live, and certainly a big issue. So thank you so much.
Thank you, Representative Money. Yeah, I wish it were isolated.
Right.
I mean, the list of dog and cockfighting busts that spans the state, Parker, Smith, Kaufman, Dallas, Harris, Caldwell, it's all over the place. And I appreciate your sensitivity to the gradation of the felony. Again, one of the challenges that this seeks to get at is the deterrent effect. Right now, it's a low-level misdemeanor. They're back out on the street. They do it again. It's the price of doing business. I think the felony, according to law enforcement and others who testified in favor, would be an effective deterrent to the activity.
Thank you.
Thank you.
Thank you, Representative Anchia.
I close.
Committee substitute amendment is withdrawn, and if there is no objection, the bill resolution will be left pending. For objection, the chair hears none. House Bill 1795 is left pending. The chair lays out House Bill 2407 and recognizes Chair Capriglione to explain the bill.
Great. Thank you. Good morning, Mr. Chairman, members. Thank you for the opportunity to address the committee today. I'm here to speak to you about House Bill 2407, which strengthens Texas's sex offender registration system by enhancing penalties for certain individuals who repeatedly fail to comply with registration requirements. Under current law, convicted sex offenders must register with law enforcement to help protect their communities and reduce the risk of repeat offenses. Unfortunately, there is a loophole in the current statute that allows some individuals to knowingly avoid these legal obligations while still not being sentenced according to the severity of the crime. This makes it harder for authorities to monitor their whereabouts and increases the risks to the public. House Bill 2407 addresses this issue by amending Chapter 62 of the Code of Criminal Procedure to increase the criminal penalty for failing to comply with sex offender registration requirements, particularly in cases involving repeat offenders or individuals who intentionally evade detection. Key provisions of this bill include fixing the loophole by correcting the statute to allow for the sentencing of the offense to a higher degree felony for repeat offenders or for those who deliberately avoid registration. It strengthens the penalties for failure to update key registration information such as residence, employment, or other required details, and providing the courts with stronger tools to hold sex offenders accountable for intentional violations. House Bill 2407 addresses the original intent of the statute to allow for the courts to properly sentence offenders for the severity of their crimes. I'm happy to answer any questions. Reserve the right to close.
Thank you. Questions for Chair Capriglione? Thanks, sir.
Great, thank you.
The Chair will call the first witness, Lauren Lawrence. Thank you for being here today. We show you registered as Lauren Lawrence, and you represent?
I represent Phil Sorrells, the elected district attorney in Tarrant County.
That's all.
And I am here in favor of this bill.
Okay, thank you.
Thank you, Chairman Louderback Committee. I was taught in law school that if you can't say it better than the court did yourself, don't, and just cite them. So I am going to cite to Carr versus State, which was a case from the Court of Appeals in Fort Worth on this particular issue. It says that based on the indictment, the state was attempting to use Article 62102C to enhance Carr's offense from a third degree to a second degree. The trial court followed the state's lead by doing the same. This was error. Article 62102C does not enhance the offense, it enhances the punishment. Under Article 62102C, using one of Carr's prior convictions, his offense remained a third-degree felony, but was punished as a second-degree felony. For the enhancement to work the way the state wanted, and as the trial court applied it, the legislature would have to write the statute differently. So we're here asking you to write the statute differently. The legislature's intent was to punish those who fail to register on a second occasion as a second-degree felony. But because of the way the statute is currently written, because it only punishes that offense as a second degree instead of making that offense a second degree, it cuts off our access to our Penal Code Chapter 12 enhancements. And so we are simply asking, what this bill does is instead of saying it's punished as a second degree, it makes the offense a second degree. That way, we still have access to our Penal Code Chapter 12 enhancements. And I'm happy to answer any questions.
Thank you. Questions, members?
Yeah, thank you,
Representative
Chairman.
Little.
What was the case site on your case?
Yes, sir. It is 685 Southwest 3rd, 206.
Thank you.
Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 2407? If not, the chair recognizes Chair Capriglione to close on the bill.
Thank you. If there's no other questions, I close.
Thank you. Thank you, Chair Capriglione. If there's no objection, the bill will be left pending.
Thank you.
The chair hears none, and House Bill 2407 is left pending. The chair lays out House Bill 2461 and recognizes Chair Leach to explain the bill.
Thank you, Chairman. Members, good morning. Appreciate you allowing me the opportunity to lay out House Bill 2461 to you this morning. In recent years, members, organized crime groups have learned how to tamper with fuel dispenser pulsers in Texas gas pumps. The pulser actually controls the communication between the gas pump and the terminal, which regulates the flow at the pump. And breaking into the pump and damaging the pulser allows those criminals to gain unlimited access to the fuel, many times by filling large auxiliary tanks and causing significant financial loss. However, when those criminals are caught, they're frequently only able to be charged with misdemeanor criminal mischief because the cost of the pulser where the damage is done is relatively inexpensive. This bill would amend the criminal mischief statute to clearly provide that damage to or destruction of a retail motor fuel pump is a third-degree felony. This will give our local law enforcement and prosecutors another tool and also provide a deterrent. Members, this language passed last session overwhelmingly, and it was Senate Bill 467, but that bill was vetoed by the governor due to disagreements on property tax reform. I'm happy to answer any questions and would reserve my right to close, Mr. Chairman.
Thank you. Questions for Chair Leach? Representative Money.
I think last week we heard something similar from Representative Palisa about electric charging. It's the same statute. It's the same concept or idea. And the question I have is, if a person commits this mischief, vandalism, whatever it may be called, and the damage is, I mean, it already says if the damage is less than 30,000, it is hold on, I've forgotten, a state jail felony, and the actor causes interruption of property. Okay. Oh, never mind. I'm sorry. Oh, there it is. But less than 30,000 or more than 150,000. So how much is one of the fuel pumps cost? Like the cost to replace or fix?
Yeah, I don't know the answer to that. I think my witness. I think we've got one witness to testify for the bill. I think they'll be able to answer that. The prosecutors and law enforcement are just Representative Money asking for another tool. Right now, they've been limited to prosecuting this as simple misdemeanor, which, you know, while serious is not as much of a deterrent as they'd like. And so this simply gives them another tool to, if they so choose, to prosecute as a third-degree felony.
Okay, thank you.
Yeah, thank you.
Thank you.
Thank you, Mr. Chairman. I reserve my right to close.
Yes, sir.
Thank you.
If there are no further questions, Chair will call the first witness. Chair calls Adam Colby.
Sir, Susanna Catrone with the Texas Department of Licensing and
Okay.
Regulation.
Let me-
Mr.
thank you,
Colby
Reed.
is on his way.
He's on his way?
Yes, sir.
Uh,
From another hearing room.
Okay. A few minutes.
2 minutes.
Please excuse
Thank
me,
you.
I was testifying on another bill.
Thank you for being here today. We show you registered as who? Adam Colby?
That is correct, sir.
Okay, so, and you represent?
The Texas Financial Crimes Intelligence Center.
Okay, sir. And you're testifying on for or against House Bill 2461?
I am for the bill, sir.
For the bill. Thank you. Okay, go ahead.
Okay, thank you very much for your time. I apologize that I was running late. I just got done upstairs in another bill. Again, my name is Adam Colby. I'm the Director and Chief Investigator for the Texas Financial Crimes Intelligence Center. This bill was written to address a sophisticated method of fuel theft called pulser tampering. In this crime, an electronic device is placed in the pump cabinet. The device tricks the pump into thinking that it's dispensing significantly less fuel than it actually is. This ends up charging pennies on the dollar for the fuel. Typically, from what we've seen at the FCIC, about 200 gallons of diesel at a shot for around $15 are being charged.
Excuse me just a minute. Now, you registered when you're neutral, but you're now for the bill?
I'm kind of as a state, working for the state, I'm not really supposed to be one way or the other. But
I need you to pick one.
I am for.
You're for the bill?
Yes,
Do
sir.
we have permission to change it on the record?
Yes, you do.
Thank you. Okay, go ahead.
Okay. So typically, about 200 gallons of diesel is what we've seen being dispensed in one shot, with a corresponding charge of $15 in the pump. However, the criminal group will typically steal anywhere from 2,000 to 10,000 gallons in a criminal episode, usually over the course of about 2 days. 200 gallons only represents the capacity of the average truck converted to illicitly store this fuel. This crime not only hits the bottom line of the fueling station, it also hits the bottom line for the state, with every gallon stolen representing a loss of tax revenue. This crime is committed by the same organized crime groups that commit gas pump skimming. In both cases, the end game for the criminals is to obtain fuel and then resell it. The Texas FCIC has worked numerous cases involving this type of fuel theft, dismantling groups as large as 20 individuals. Despite the success, we are continuously hamstrung by the lack of anything in the penal code to address the actual device. This bill would provide another tool for us to use against organized crime. As industry and law enforcement figured out what pulsar tampering is, it evolved into other methods, such as wiretapping in the pump. It does the same thing. It basically steals for pennies on the dollar. Again, none of these crimes are addressed in the penal code, and the use or possession of these devices can only be addressed with a handful of statutes that are cumbersome and often carry very little no weight, such as possession of a criminal instrument. This bill is ingenious in that it doesn't have to address the device. Simply entering and altering the pump cabinet becomes a third-degree felony. Having this offense on the books would give law enforcement a tool to arrest the criminals and hold them while a deeper investigation is carried out for engaging in organized criminal activity. Additionally, since this does not address a specific device type, the bill enacted as law would address any type of device that the criminal group may come up with to commit fuel theft by entering and altering the pump. Thank you for your time. I'm happy to answer any questions you may have.
Thank you. Members, are there any questions of this witness? Thank you, sir.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 2461? If not, the chair recognizes Chair Leach to close on the bill.
Thank you, Mr. Chair. I'm happy to take questions. If not, I'll close.
Seeing none.
All right.
Thank you.
Thank you,
Chair
Mr.
Leach.
Chairman.
If there is no objection, the bill will be left pending. Chair hears none, and House Bill 2461 is left pending. The chair lays out House Bill 285 and recognizes Representative Ordaz to explain the bill.
Good morning, Chairman Lauterbach, Representative Speaker Moody, Representative Little, and Representative Money. Thank you for allowing me to present this piece of legislation today. And I also want to thank the bipartisan co-authors who are sitting on the dais today. HB 285 is to protect pets from those who commit animal abuse through criminal negligent actions. The Texas Penal Code on non-livestock animal cruelty states that a person commits an offense if the person intentionally, knowingly, or recklessly kills or causes serious bodily injury to the animal by actions such as torture, abandonment, cruel transportation, and more. Too often, cats and dogs are injured or killed from the negligence when people act without concern for harmful consequences. For example, people have taken their pets to be groomed, anticipating the return of a clean and happy pet. Then, through negligent behavior, groomers have left pets in dryers for far too long, tightened their collars too tight until they choke, or lost them in a facility that is easy for a pet to escape. Instances like this happen too often. Currently, attorneys are unable to seek justice for families whose dogs or cats have been harmed due to negligent conduct, and these bad actors are able to potentially harm other animals. This bill exempts veterinarians and their assistants for criminal negligence charges and keeps them at the same liabilities as before HB 285. As a pet owner myself, our pets become members of our family, and we should do everything we can to protect them from harm. Thank you, Chairman Lauterbach, members. I have a few witnesses here to tell their stories. I respectfully reserve the right to close and ask for your favorable consideration.
Thank you. Members, questions for Representative Ordaz? Thank you. If there are no further questions, the chair will call the first witness. Is Paul Mecca. Thank you, Paul. We show you registered as Paul Mecca. Yes. And you represent?
Myself. Yes.
Yourself. Yes. And you are testifying on, for, or against House Bill 285?
For
the bill. Thank you.
I want to start by thanking the committee, also Representative Ordaz, the other authors, Leach, Mayor Moody, and Cook, and also Bowers, Lauterbach, Money, and Verdell. And also want to thank my wife, Maria. She's worked on this for the last 3.5 years since we experienced this ourselves. And also want to mention that we've talked to our Senator, Royce West, and he has indicated that he will support this in the Senate. We were here 2 years ago. We had a unanimous vote out of this committee to move forward. We just ran out of time to get to the floor and vote. I wanted to point out one part. There's a letter from Randy Turner, Texas attorney, that y'all should have. And there's a notable part where he says, these pet service businesses have no legal incentive to be careful and not commit negligence. I think ultimately that's why we're here. This is the get out of jail free card for them. They can say, oops, it was an accident, and that's it. So that's what this bill is about. Just cleaning up that little bit of language so that negligence is no longer the easy way out. By doing that, that creates accountability, and I think the businesses will respond by taking this much more seriously, investing more time and attention into the care of these animals that they are being paid to care for. With that, I thank you for your time and kindly request that you consider this bill.
Thank you. Members, any questions of this witness? Thank you. The chair calls Maria Mecca. Thank you for testifying today. We show you registered as Maria Mecca,
Yes,
and you represent
myself,
myself. Thank you. And you're on for or against House Bill 285?
for the bill.
For the bill. Thank you.
My name is Maria Mecca, and I'm here to testify in support of Poncho's Law, House Bill 285, on behalf of myself and other Texans who have had their dogs killed by Texas pet service businesses. 4 years ago, my dog Poncho, a 2-year-old black lab rescue, was killed by a Dallas dog daycare, and his body was dumped among the trash. My husband and I quickly learned that there's a loophole in the animal cruelty law that allows pet service businesses to act with impunity by simply claiming negligence. All they have to say is, I didn't mean to kill your dog, no matter how egregious their actions have been. We started the Poncho's Promise Foundation, began working with Representative Ordaz, who also had constituents in her district experiencing tragedies like ours, and connected with hundreds of Texans who have experienced similar tragedies. Here are some of those Texans' stories. Sonny, a Pomeranian in Lake Highlands, Texas, was killed by a dog daycare after his larynx was crushed by a leash. Indy, a golden retriever in Spicewood, Texas, was killed by a dog boarder who lied until the police found Indy's body actually buried on the property. Moose, a St. Bernard in Austin, Texas, was killed by an Austin, Texas dog trainer who stuffed his body in a tiny crate for the family to pick up and claimed he didn't know what happened. Hallie, a chocolate lab in Dallas, Texas, suffocated to death at a dog daycare when her collar hooked to one of the 20 dogs she was left alone with unattended. Leia, a doodle in Round Rock, Texas, was killed by a dog daycare who dumped her body in the trash to hide the evidence. Arlo, Figgy, and a third Labrador retriever from our Dallas rescue were killed by the same dog trainer on separate occasions, and another rescue Labrador with the same trainer came away with a missing eye and fractured skull. Roland, a Chihuahua in Austin, Texas, and Tummy Rub in Carrollton, Texas, were both killed by negligent doggy daycares. Pippa, a French bulldog in Tarrant County, Texas, and Blue, a husky in Leander, Texas, were both killed by boarders who left them out in the hot Texas sun to die. Nutella Rose, a miniature schnauzer in South Texas, was killed by a groomer after she was left unattended, tethered to a table, unfortunately fell off and hung. Ollie, a Maltese, Lexi, a mixed breed, both in San Antonio, Texas, Teddy, a Yorkshire Terrier in Cedar Hills, Texas, and Coco, a Chihuahua in Corpus Christi, were all
Ms.
killed by
Mecca.
different groomers.
Thank you very much. Members, any questions of this witness?
Okay.
Thank you.
Thank you very much.
Chair calls Heather Kutbia. I don't think I got that right. Thank you for being here. We show you registered. How do you pronounce your last name?
Katiba.
Ki-
Katiba.
Katiba. And you represent
Myself,
yourself. And you're testifying on for or against House Bill 285?
I am testifying against House Bill as written.
You're against.
That is correct.
Thank you. Go ahead.
Very good. Thank you, Chairman, committee members. My name is Heather Katiba. I oppose House Bill 285, carry-in Section D1, which seeks a statutory defense to prosecution for criminal negligence by a veterinarian or anyone assisting. This bill does not offer greater protection or justice. It doesn't uphold the law, it undermines it. If knowingly and intentionally shields bad actors behind the false veil of professional duty. Governor Abbott has stated, and I quote, 1, licensure exists to protect the health and safety of the public. 2, criminal activity perpetrated by license holders or non-license holders should be prosecuted under the statutes that are relevant to the activity, and rightly so. 3, he reminds us, a license is no guarantee that the holder will not engage in a criminal activity. How well I know this. All medical professionals are held to a high standard of law, because they operate in domains that affect lives. A license is not and has never been a license to harm. This bill proposes we accept criminal negligence as an occupational hazard, another way of doing business. Extending to anyone loosely categorized as an assistant, all well outside of the regulatory authority. To be clear, the Texas Board of Veterinary Medical Examiners, as proposed by lobby, cannot bridge a gap of accountability. The state board is an administrative body. By the separation of powers doctrine, the agency has no jurisdiction over criminal proceedings. By law, the agency is mandated to query licensee criminal conduct through fingerprint-based background checks, track arrests and charges, and impose disciplinary actions for illegal practices. During open meetings reporting, it is not if there are criminal cases ongoing, it is how many. The agency does not have authority or jurisdiction to pursue nor prosecute crimes. It regulates by policy. It licenses. The proposed section contradicts established statutory framework, suggesting licensees be exempt from judicial scrutiny, despite legislative strong policy to ensure accountability as any other professional. The judiciary exists not to follow public opinion or political agendas, but to uphold the law, protect rights, and ensure that justice is delivered impartially, a safeguard that defends, especially when those rights are inconvenient to those in power, official, or licensed positions. A defense to prosecution for alleged criminal negligence occurring under the duties performed by a veterinarian or their help under Chapter 801 exceeds, if not violates, the scope of regulation. As a longstanding member of the veterinary industry and also when impacted by serious egregious harms at the hands of a licensee, history and current judicial rulings should not be ignored by the public, this legislative body, nor the profession. If this body believes our cruelty statutes and penal codes are insufficient, let us strengthen them through comprehensive reform on its own merit, not by legitimizing criminal behavior under the guise of professional duty. The standard for those sworn to protect should never be less than that expected of the public itself. Law identifies it must be higher. With professional authority and fiduciary duty comes greater responsibility.
Thank you for your testimony. Members, are there any questions? None. Thank you very much.
Thank you.
The chair calls Ashley Morgan. We show you registered as Ashley Morgan, and you represent?
Myself and the Texas Humane Legislation Network.
Okay, and you're testifying on, for, or against House Bill 285?
I am for the bill.
For the bill. Thank you. Go ahead.
Thank you. Mr. Chairman and members of the committee, thank you for having a hearing on this bill today, and I'm very appreciative of the authors of this bill and note the bipartisan support. I'm a board member of the Texas Humane Legislation Network. I'm also an attorney who practices in Austin, Texas. I've been practicing law for 8 years. I've practiced primarily civil litigation as well as family law. I have also served as the chair of the Animal Law section of the State Bar of Texas, and I'm currently the chair of the Animal Law section of the Austin Bar Association. I'm in favor of House Bill 285. It would add criminal negligence to the animal cruelty statute. This is important because as it stands, it's only animal cruelty if a person acts intentionally, knowingly, or recklessly. Pursuant to Texas Penal Code Section 6.03, a person is criminally negligent when he ought to be aware of a substantial and unjustifiable risk that the circumstances exist or the result will occur. And the risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the actor's standpoint. So this is greater than civil negligence and closer to, if you're familiar with gross negligence, in Chapter 41 of the Texas Civil Practice and Remedies Code. As the Court of Criminal Appeals put it in Williams versus State, criminal negligence depends upon a morally blameworthy failure to appreciate a substantial and unjustifiable risk, whereas recklessness depends on a more serious moral blameworthiness, the actual disregard of a known substantial and unjustifiable risk. So as you've heard, this closes that loophole where someone can say, well, subjectively, I just didn't know, whoopsie, I didn't know that I needed to exercise this care. This bill is necessary because under the current law, there's little to no recourse for pet owners whose pets are injured or killed by an individual whose pet owner has paid and entrusted someone with their animal. In the civil context, I get calls from folks on a regular basis whose animals were killed by someone they paid to care for those animals, and I can't do anything to help them because you can't get attorney's fees, and all you can get is the fair market value of the animal. I want to address the last witness's comments. This exception for veterinarians is just a defense. That does not mean that they can't be prosecuted if they are failing to exercise the care that they should be in their role as a veterinarian or if they're exceeding that. So, for example, you may receive calls from...
Thank you.
Oh, okay. Thank you. I ask you to support the bill.
Members' questions,
I'm
Ms.
sorry.
Rose?
I want you to drill into the last point you were making because I want to understand that distinction.
Yes, so there's an exception in the bill as written for veterinarians who are acting under the scope of their licensure. So one of the examples that y'all may hear about in the folks that are calling against the bill is there was a veterinarian at Texas A&M named Ashley Watts who was convicted of animal cruelty under a different statute. So this only impacts the non-livestock statute. She was convicted under the livestock statute. So that's one important distinction. But the other thing I want to draw is that she, as a defense, even where there wasn't a statutory defense, said, I was just acting in my role as a veterinarian. What she did was she applied an electric cattle prod to a horse, to its ear canal and its anus, almost 1,000 times. And the jury found, rightfully so in my humble opinion, that she was not acting as a veterinarian and that she was acting in a cruel manner. So my point is people can still, even if they're veterinarians, be prosecuted if they're going outside of what would be standard veterinary care. And this exception only applies to criminal negligence, not to the intentional, knowing, or reckless components.
No, thank you. I appreciate that, and thank you for the indulgence, Mr. Chair. That's an important distinction that we need to talk about. Thanks.
Yes, thank you very much for your question.
Members, any other questions? Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 285? Now, the chair recognizes Representative Ordaz to close on the bill.
Thank you, members, so much, and I just really appreciate the time that each of you have taken with me to go over this bill, so I appreciate this, and I close. You all have a good day.
Thank you, Representative Ordaz. If there is no objection, the bill will be left pending. Seeing none, the chair hears none, and House Bill 285 is left pending. The chair lays out House Bill 795 and recognizes Representative Johnson to explain the bill.
Good morning, Chairman.
Good morning.
Members, thank you for the opportunity to lay out House Bill 795. Representative Money, I'm glad you're on this committee. As we talked about earlier, this bill is not about restricting gun access or gun rights or even just possession or exhibiting a gun. What this bill addresses is a rising crisis in our state with regard to road rage. Specifically, in the city of Houston, over the last decade, we have seen over 215 incidents where people have been shot. Back in the old days, somebody cut you off and you might honk your horn. somebody swerved in front of your lane, you might even shoot them the bird. But now people are pulling out a gun and they are firing a weapon. And there is a problem in the code. There's a good provision on aggravated assault deadly weapon, but we're missing the element of addressing what we are all seeing on social media. When people get outraged, people jump out of the car at an intersection and they pull a gun on another person. And if they discharge, in a way that can cause an injury to the other individual, I am asking that you bump that up to a first-degree felony. Right now, the law accounts that if you are firing out of a vehicle and you cause serious bodily injury, it's a first degree. This bill creates a bubble around the vehicle that if you fire at that vehicle and you strike property of the vehicle, a tire or bumper, or you fire at that vehicle and it is close enough that it causes imminent fear of serious bodily injury, that would be a first degree. You are going to hear from two parents. You are going to hear from the fathers of David and Louise. You are going to hear about the suffering when that bullet hits your child. We have the ability and the responsibility as a state to send a public policy and a deterrent to tell people that when you get mad in your car, you do not pull out your gun and you do not fire. Because when you do, you destroy lives. I appreciate very much your attention to these witnesses. I'm happy to take any questions. Otherwise, I reserve the right to close.
Members, questions?
Thank you, Representative Johnson, for this very, Thank you, Mr. Chair. Thank you, Representative Johnson, for this very important bill. I have to say that I heard this story when we were in full committee, and it has kind of stuck with me, and I haven't been able to shake it. So thank you for addressing this bill, and thank you for inviting this family to come and join us today.
Thank you, Representative Little. Thank you, Chairman. I reserve the right to close.
Thank you.
Thanks.
If there are no further questions, the Chair will call the first witness. Chair calls Daniel Wilson. We show you registered as Daniel Wilson.
Correct, sir.
And you represent who?
Myself.
Yourself. And you are testifying on for or against House Bill 795?
For, sir.
For, sir. Okay, thank you. Go ahead.
Chairman, members, thank you for your time. Good morning. My name is Daniel Wilson. I'm here today as a grieving father, a veteran, and a Texan. On December 10th, 2023, my 17-year-old daughter, Louise Wilson, was shot and killed in a roadway shooting in Houston. She was just trying to enjoy a normal day, heading to Galveston with friends for some time at the beach. That day, which should have been full of laughter and sunshine, turned in our family's darkest moment. Louise was just trying to avoid an accident when she braked suddenly. That was all it took for someone to pull up beside her and open fire. She was hit twice, once in the chest and once through the legs. And just like that, she was gone. Maybe this shooter thought they would just scare her. Maybe they just wanted to get her attention. HB 795 would rightly make those types of scenarios a first-degree felony, as it should be. Texas leads the nation in roadway shootings. From 2014 to 2023, there were 741 firearm-related roadway incidents reported in our state. Houston alone accounted for 215 of those cases, the highest of any city in the United States. And those are just what's reported. But this just isn't a big city problem, and it isn't confined to one area. It's a Texas problem, one that reaches into every corner of our state and destroys lives. I served 20 years in the military, deploying multiple times to combat zones, and I've seen the long-term impacts of post-traumatic stress. No one, especially civilians, should have to deal with the kind of trauma because they went out for a drive or spent time with friends. This epidemic of roadway violence is tearing at the fabric of our communities, and it's past time we did something about it. The bill we're considering today is a necessary first step. Far too often, people who commit these violent acts get away with it, or they repeat them again and again. I've spent countless sleepless nights thinking about the person who killed my daughter, how quickly they made the decision to pull up beside her car and fire their weapon. Were they waiting for this kind of opportunity? Obviously, they were ready. Did they even think for a moment about what they were doing? It's chilling to imagine that there are people on our roads capable of such recklessness and harm. Maybe this bill would make them pause. Maybe it will save another family from experiencing the unbearable loss that mine has endured. Thank you, Chairman and members.
Members' questions? Thank you, sir. The chair calls Kim Ogg. Thank you for being here today. We show you registered as Kim Ogg, and you represent?
I represent myself.
So,
My name's Kim Ogg. I'm the former Harris County.
And you're testifying on for or against House Bill 795?
Forgive me, Mr. Chairman. I'm testifying for House Bill 795 and its support.
Thank you.
My name is Kim Ogg. I'm the former Harris County District Attorney from 2017 until 2024. I'm a board-certified criminal lawyer of almost 38 years. I'm here to emphasize what Representative Johnson, the Wilson family, and what Paul Castro will talk to you about, and that is we have far too many deaths occurring because of road rage shootings. I had dozens, literally, during my 8 years as district attorney, but we had far more cases where serious bodily injury was inflicted. Somebody didn't die. No thanks to the perpetrator, just thanks to EMS, thanks to the Lord, etc. So this bill would raise the penalty for aggravated assault committed with a firearm out of a car or on your way to a car to a first-degree felony appropriately. It would give Texas juries and judges the opportunity to sentence somebody to between 5 and life in the penitentiary as opposed to just a maximum of 20 years. I'm grateful to Representative Johnson for filing it because it reflects the attitude and wishes of our county residents. We want to be safe on the roadway. And Texas and Houston are very car-centric places. That's part of the reason we lead the nation in these types of crimes.
Thank you. Members' questions?
Thank you for,
Money.
excuse me, thank you for coming to testify today. This bill seems to me to do two things, or change the law in two ways. The first one says that the law currently says that the actor must be in a motor vehicle, and this changes it to say if it's inside of or directly en route to or from a motor vehicle, so that in the case we're talking about here, someone gets out of their car and shoots someone, it's the same as if they shoot from their car. Makes a ton of sense. The other part of this, it says it looks like there's three elements once you get past the directly en route to or from a car. Knowingly discharges a firearm in the direction of a habitation, building, or vehicle, is reckless as to whether the habitation, building, or vehicle is occupied, and third, in discharging the firearm, it currently says causes serious bodily injury to any person. And what we've done is we said, hey, even if you don't cause serious bodily injury, if you cause any bodily injury to a person or damage to any property or place any person in fear of imminent serious bodily injury. And so my question is, now that we are, and I'm in favor of this, by the way, we are lumping all of these things in together where my question is C even necessary? And you're a prosecutor, I'm not, but if someone knowingly discharges a firearm in the direction of a habitation, building, or vehicle and is reckless as to whether the habitation, building, or vehicle is occupied, why does the prosecution then also need to prove that they either caused bodily injury or damage to property or placed a person in fear of imminent serious bodily injury? If we eliminated that C section, would it be easier to prosecute still capturing the same people and not getting people that we don't want to get? Does that make sense?
Yes, and I have to, of course, defer to the bill's author, Representative Johnson, about her thoughts on it. Mine would be much like carjacking, which was made into its own offense category. I think it makes it easier for the jury to understand. What you read is a little bit complicated when you explain to a jury all of their choices. I think this simply makes a very specific requirement in these types of road rage shootings, not requirement, gives you a specific statute really designed to get at that crime. I would say it's easier to probably explain to a jury. It certainly raises the penalty. I think that's the point of the bill. But you're right, we have a statute now, and we utilize it in certain situations, shooting at houses, shooting at cars. I just think this makes it more specific and easier to understand.
Sure. I guess what I'm getting at is, in what scenario could someone knowingly discharge a firearm in the direction of a habitation building or vehicle and be reckless as to whether that habitation building or vehicle is occupied and not automatically place a person in fear of imminent serious bodily injury?
Sleep in the house.
Okay. And if a person is asleep in the house and doesn't know, and it doesn't cause bodily injury and it doesn't damage property, do we want to enhance that penalty already as well? We don't? Okay. All right. Okay. That makes sense. Thank you. I apologize for the off-mic conversation with my friend, Ms. Johnson. But
I want to thank her for answering the question.
yeah. Okay. So yeah, I appreciate that. Just trying to work through scenarios in my head, and I don't like to have things in the statute that the prosecution has to prove that make it more difficult, that don't add value. So that's good. Thank you very much.
Thank you.
Thank you. Any other questions?
Excuse me.
Representative Little.
Thank you, District Attorney Ogg. I've got some questions here since we're thinking about changing the statute. You served Harris County for a long time. What's going on here? Why do we see this particular offense to this particular degree in Harris County as opposed to other places? And I'm sure you have insight into this, having served in your role for a long time. I find the answer that Houston is a city that drives a lot to be unsatisfying, and I'm curious what you think the other causes may be.
Well, thank you for the question. I don't believe that Houston is that much different than other major urban areas in the state or in other states where we see a high rate of road rage shootings and killings. Houston's just really big. We cover more than 1,600 square miles in the county, 1,200 in the city, and Houston's a car-centric place, much like Texas is car and truck-centric. And I believe that the increase we saw in violent crime has happened because many people are out on bond for other offenses in Harris County. I think that's contributed to the violence in every single violent crime category. And I also believe that COVID and Harvey and other exacerbating factors have made people, I think, short-tempered and reacting in a more violent way. I certainly, if I had the answer to why people do evil things, none of us would have to be here. So I can't answer for why it is, but I think we are car-centric. We've just got a whole lot of people. We got a lot of miles. And unfortunately, we have people who react in illegal ways who ought to be behind bars.
Thank you for your insight.
Thank you. Members, any other questions? Thank you, ma'am.
Yes, sir. Thank you.
We have about 20 minutes before we have to go to the floor, so we've got about 20 minutes left before we do that. Thank you. The chair calls Paul Castro. Thank you for being here today. We show you registered as Paul Castro.
Yes, sir.
And you represent?
Myself.
Yourself. And you're testifying on for or against House Bill 795?
For
the bill. Thank you.
A couple of weeks ago, I shared the story of my son David, and that time, July 6, 2021. I wanted to thank you for allowing me to come back. Immediately after David was killed, Representative Johnson met with me and we had conversations. At the time, I was still suffering from PTSD, and she suffered me as I suffered back. And at the time, she promised to try to do something about helping to make Texas roadways safer, and I thank her for writing House Bill 795. The thing that I think we're trying to do, and I think all of you are in support of this, is we have to find ways to help take the dangerous people off our street. As former DA Ogg mentioned, there are some dangerous people on our streets who have short tempers. I've worked in the public school system for 30 years, and what I've seen is a gradual change over time. And in that gradual change, people seem to take high offense to low-degree things. And in taking high offense, the move to violence seems to be happening quicker and quicker over time. What I hope happens is, as a result of this, I know a lot of my friends are getting cameras in their vehicles, and if something were caught on video and a person were waving a gun, shooting a gun up into the air near a car and missing, that's a person who is a time bomb waiting to go off and a person who's waiting to hurt another person seriously. We want to give DAs and juries opportunities to take those people off the street. Right now, Harris County has I think 900 people who are out on bond who are accused of murder. These are the types of people who are very dangerous and who are probably the small offenders who are creating the violence that impacted our family and the family of Louise and others like them. We ask that you please provide this bill an opportunity to see the floor and get passed into law. Thank you.
Thank you. Members, questions? Thank you, sir. Chair calls Andy Kahn. Thank you for being here. We show you registered as Andy Kahn. You represent who?
Represent Crime Stoppers of Houston.
And you are testifying on for or against House Bill 795?
Testifying for.
For. Thank you. Are you representing yourself?
Yes, I am.
Thank you.
Okay. My name is Andy Kahn. I'm Director of Victim Services, Crime Stoppers of Houston, and I'd like to thank Representative Johnson for filing a very important bill, especially pertaining to what we're seeing in Houston and Harris County, but it's actually statewide as well. The last few years at Crime Stoppers, we've been putting out more rewards for people involved in road rage shootings than we've ever had in our entire existence, and it's a disturbing trend that we're seeing. Considering it at an average, every person is shot in a road rage incident just about every 18 hours. That was the last known statistical data, and that was in 2023. There's about a 450% increase in road rage incidences from 2014 to 2023. And to put it in perspective, if someone was shot in a road rage incident in 2014, it was every other 4 days. Sadly, right now, it's less than a day in the entire state of Texas. And this is not a good category to lead the nation in. It's not something you want in the Welcome to Texas Chamber of Commerce brochure. We are far and above anywhere else in the entire country. Nobody comes close. We dwarf who's number 2 and who's number 3, which is Florida and California. And in Houston, we double the amount in any other city in the country. This is not something to be proud of. Legislation filed by Representative Johnson will give a little bit of teeth, more teeth, because when you're shooting and firing into a vehicle or anything else, there's an intent there. And whether you take someone's life or not, the full amount of the law should apply, period. You shouldn't be rewarded just because the person that you were shooting at lived. That's what this does. And keep in mind that there's a lot more people alive today who 10 years ago probably would have died, but through medical technology and advances, they remain alive. We wholeheartedly support this bill. Thank you for your consideration.
Thank you. Members, do you have any questions?
Thank you.
The chair calls Stephen Driver. Thank you for being here today. We show you registered as Stephen Driver,
That is correct.
and you represent who?
The Harris County District Attorney's Office and myself
And yourself, thank you. You're testifying on for or against House Bill 795?
for the bill.
For the bill, thank you.
I'm here because there is a little bit of a gap in the aggravated assault statute, particularly when it comes to the enhancement for individuals who discharge firearms from a vehicle, and in particular in the context of a road rage incident. So I'm very grateful to Representative Johnson for bringing this bill. I can tell you that we have, whenever somebody shoots from a vehicle and shoots at a vehicle or a habitation, one of two things happens. Somebody is injured, and generally, we aren't filing a whole lot of these charges with the enhancement because somebody dies, in which case they're charged with a murder or a manslaughter, or they're charged with capital murder. So right now, this enhancement, though helpful, it's underutilized from the boots on the ground perspective. It would be much more helpful if we had the tool that Representative Johnson has proposed in this legislation. So if you are somebody who is engaging in a road rage incident, you take a firearm and you exit your vehicle, or you are in your vehicle and you fire at somebody, at a vehicle, at a habitation, that conduct by itself should be a first-degree felony. And the reason I know that is because we have a whole bunch of people committing it. And in other words, there's not sufficient deterrence with the law as it exists right now for that kind of offense. You heard Mr. Khan testify that we're going up. This number is huge. And in order to combat that really disturbing trend in statistics, we needed the tools to be able to put people in custody longer and to provide a strong deterrence from engaging in that kind of conduct. So I'm in support of it. Please vote in favor of it.
Members, any questions of this witness? Thank you. Chair calls Chris Harris. Thank you for being here today. We show you registered as Chris Harris, and you represent?
Texas Civil Rights Project.
Say again?
The Texas Civil Rights Project.
Okay, and you testifying on for or against House Bill 795?
Against.
Against. Thank you. Go ahead.
Yeah, sure. Well, firstly, I would just want to say that obviously our hearts go out to the families and everyone victimized by tragic incidents of road rage across the highways and streets of Texas. And our opposition to this bill, in short, is related to what we believe is some overbroadness that allows certain actions to be prosecuted at the same level as other actions, which are clearly much more heinous. And you can see it right there in the statute. And specifically, what we're concerned with is the notion that someone could recklessly fire into a habitat or vehicle, potentially not connected to a road rage incident, no one be hurt because it literally just says coming to or out of a vehicle, right? So it's not necessarily that it's connected to a road rage incident, and that no one be hurt, but someone claimed that they were made afraid, and that is now would be charged at the same level as someone who's committing a mass shooting, where they are actually committing serious bodily injury to one or more individuals. And so again, our desire is to ensure that if there are, to the extent there are gaps in the penal code with respect to covering incidents of road rage, this specific traveling to or from a vehicle, we want to work with the author and the folks in this committee to ensure that those gaps are closed. However, we also don't want to make a situation where incidents where no one is hurt and it's not actually related to the incident that we're all here talking about is covered at the same incident. The last thing I'll just say is, her word deterrent has been used a lot. And, in general, the facts don't bear out that enhanced penalties to almost any offense represent a deterrent. And especially when we're talking about a heat-of-the-moment incident, something we're literally calling rage, right?
Thank you.
The idea that this will deter is, I think, a misnomer.
Members, any questions to this witness?
So, yes.
Representative Money?
Mr. Chairman,
Mm-hmm.
is Is it your position that if the person isn't angry because of a road-related incident, that they should be able to shoot into somebody's car?
Of course not. The question is whether or not this should be a first-degree felony. Again, analogous to someone who commits a mass shooting and harms multiple people.
Okay. I've long been frustrated. I'm a hockey fan. I'm frustrated that sometimes penalties depend on how bad the person is hurt rather than how bad the conduct is. If I hit somebody in the stick with in the face with my stick, it's 2 minutes. If I hit somebody in the face with my stick and they bleed, it's 4 minutes. That seems not fair. I can't really control how much the person bleeds. If you knowingly discharge a firearm in the direction of someone's vehicle and are reckless as to whether or not that vehicle is occupied by a human being, should you not be punished because you are as though you were recklessly shooting at a human being, which in most cases you are?
And again, our concern is not that someone not be punished. Is it analogous to a mass shooting where someone is intentionally firing at multiple people and actually creates serious bodily injury to multiple people versus an incident where I am reckless about whether someone is in a habitation or a vehicle and potentially no one is hurt, but someone claims fear. So to us, those are not analogous situations deserving of an equal penalty. Again, our issue is not to say that road rage isn't a serious incident and we should close gaps in our penal code that don't reflect or enable people to be held accountable for that behavior. We certainly believe that should happen. The question is whether or not we're talking about an enhancement and language that is going to be restrictive enough to the incident at hand and is ultimately creating penalties that make sense within the scope of the rest of the penal code.
Well, I think the jury will still have an opportunity in working in conjunction with the prosecutor to determine what the penalty is between, I think they said 5 years and life, and that would, I'm sure, determine whether or not the person, is actually injured and all of the factors that you've put in place. I'm certainly with you that if we want to take mass shootings and increase the penalties for that, we can have that discussion at a later time.
Thank you for your questions.
Chairman.
Thank you. Representative Money, Representative Little.
Hey. Thank you, Mr. Chairman. Mr. Harris, this is not it. This is not the battle you want to pick. I enjoy hearing Texas Civil Rights Project's testimony on other bills. This is not the one you need to be testifying on. We have a serious problem here. And the issue is not so much a deterrent, because how do you deter someone who decides to pull out a firearm and shoot into another vehicle? The issue is the punishment. And yes, we do want to punish those people, just like they were a mass shooter. We do.
And again, if we understand that might be the will of this body, and then the question for us is just, have we made the language such that we are capturing specifically that type of incident and not necessarily other things that aren't road rage incidents?
What types of things do you want us to make sure that we're not capturing?
Well, again,
give me a for example.
Our read of the language is that anyone who fires recklessly, potentially into a habitat or a vehicle, not necessarily, again, associated with a road rage incident, again, not something that we're saying should go without accountability in any respect, but if anyone then can claim fear, again, this doesn't have to be associated with road rage, could then be charged as a first-degree felony.
Excuse me, I need to recognize that Representative Bowers is here.
And again, we're completely understanding of the serious issue that road rage is both in Harris County and Texas more broadly, and don't want to minimize that in any way, shape, or form, or the harm that's caused. We're simply hoping to ensure that the statute reads clearly enough such that we're only capturing those types of incidents and not others.
Pretty dang clear to me. Thank you, Mr. Harris.
Is there anyone else who wishes to testify on, for, or against House Bill 795? If not, the chair recognizes Representative Johnson to close on the bill.
Thank you, Chairman. And if I may address 2 points. One, you're right when you said, look, let's not expand this too far. And the 2 changes that are in this bill are recognizing that nucleus that we see on social media of people getting out at the red light, getting out of the car. It is already against the law to be in the car and fire from another vehicle. That little step that we have, and we've worked with this with prosecutors on it, inside of directly en route to. It is intended to be that short amount of time. Not you got out of your house, you're walking from your car to your house. It's intended to be around that nucleus. And then placing a fear or having property damage is also a bubble around the space that you fired at. As you mentioned, when could we not do this? If I'm asleep in the house. I wasn't placed in fear until after the shot happened, and that doesn't help the prosecution. So you can have an either or. But currently the law says you have to draw blood. You have to cause serious bodily injury. And you're right. I'm trying to focus on the intent of the individual that is willing to pull out a gun on the road. And so we all warn our kids, don't put yourself in a bad situation. Don't put yourself with a group that can be a harm. We are talking about the fact, as all these witnesses have testified, these are just people driving down the street. This is anyone, anytime, any place if you happen to use the road. And if people are firing those guns, they're not thinking about who they're hitting, but they could hit anybody and everybody on the road. And that's why we want to protect that population. I appreciate your favorable consideration on the bill. And I close.
Thank you, Representative Johnson.
Thank you, Chairman.
If there's no objection, the bill will be left pending. Chair hears none, and House Bill 795 is left pending. You better go. You better go. The chair moves that the committee stand in recess until final adjournment, recess of the House, or during bill referral if permission is granted. Is there objection? Hearing none, the motion prevails. The committee stands in recess.